Good morning. I'm Todd Lewis, legal counsel to the Louisville Metro Ethics Commission, and today we'll be going over topics from the Louisville Metro Ethics Code. I want to begin with an introduction from our chairperson, Dee Pregliasco, who was unable to be here today due to the inclement weather while we're filming. Chair Pregliasco says, "Welcome, everyone. The Ethics Commission believes that this training, besides being required for your job, is critical for helping you to understand the ethics code in a practical way, a code that helps government employees to be transparent, to do the right thing, and to remember who you are serving, the public and the public interest." Today we have about 7 topics, and the most we're going to be able to accomplish is hitting the highlights of each one of those. All of our slides will be available to you to go through on our website or through your department if you want to look at more depth. The real point of today.
Because this particular video is going to boards and commissions, not
Oh, it is?
employees.
Okay, well, all right. Where were we?
Let's just go back to the top then. It's not critical, but I would, just to keep it evergreen.
What are we doing for Metro employees?
I don't have anything to do with it, that's through Ernest. I'll call it handle boards and commissions.
Could we do one filming that covers everyone so that they can have it? I mean, there's not much difference between, we talk about who's covered by the code.
Say Metro employees and board and commission.
Right, gotcha.
And then we can send it to both.
Okay,
We do, boards and commission members need to know that this
got
is
it.
for them.
That makes sense. Okay,
And
go.
when possible, I would mention names, dates. It would just have a longer life.
Yeah, well, we're supposed to do this once a year, so.
But, yeah, and then somebody leaves 2 months from now, and then let's do it. But it's
Right.
not critical. I just kind of keep that in the back.
Okay.
All right, we're still at
Good morning, I'm Todd Lewis, legal counsel to the Louisville Metro Ethics Commission. And this morning we're going to be talking about the requirements of the Ethics Code, particularly as it relates to Metro officers and members of boards and commissions. The following introduction is from our chair, Dee Pregliasco, who wasn't able to be with me today. Welcome. The Ethics Commission believes that this training, besides being required as part of your position, should be critical for helping you understand the ethics code in a very practical way. It's a code that seeks to help government be transparent, to do the right thing, and to remember who you are serving, the public and the public interest. Today, the topics, as we set out in slide number 3 here, that we're going to try to hit on are the definitions used by the ethics code. Number 2, the 5 or 6 standards of conduct, which are required of Metro officers and members of boards and commissions. The financial disclosures that you will be required to file and update. The standards for nepotism. The procedures of the commission through complaints and advisory opinions. The protection of employees with regard to allegations of a violation of the ethics code. And finally, our newest provision of the Ethics Code, lobbying, which, believe it or not, is actually going to have a practical effect on all employees, including members of boards and commissions. In slide number 4, I've put the website for the Ethics Commission so you can find most of this information, including a copy of the code itself if you find yourself needing to research anything or reaching out to the commission or locating the forms that you'll need to file, such as financial disclosures. In slide number 5 here, who is the Ethics Commission? It consists of 7 members. They are appointed by the Metro Mayor and then ultimately approved by Metro Council. The code says that they are to be chosen by virtue of their known and consistent reputation for integrity and their knowledge of Louisville government affairs. Having served as their legal counsel for a year, I can assure you that's true of all 7 members of the commission. There is an attempt by the code to ensure that they reside in different Metro Council districts so that we represent everyone geographically throughout the county. They serve for a term of 3 years at a time, and they are allowed 1 consecutive term, so 2 3-year terms consecutively if they are reappointed. And there are provisions for removing members of the commission for what's considered malfeasance. I don't believe that's ever occurred, but there is such a provision. There is a requirement that Metro officers and others covered by the code attend a training session, so if you're watching me today, you're doing that. Let's talk about the definitions in the code. Beginning with slide number 8 here, the important ones that I want you to be aware of are the definition of a conflict of interest, the definition of an entity, of a financial interest, since that impacts when an issue presents a possible conflict of interest under the code, and then the notion of what's called a private interest. For many of you, you serve in some capacity with regard to non-governmental, nonprofit organizations, and you will want to know how your association with a nonprofit is impacted by the ethics code as well, and that's where the term private interest comes in. First of all, a conflict of interest. It has a general definition that says here in slide number 9, any action, decision, or recommendation by a Metro officer, and that would include, by the way, when I say Metro officer, assume until told otherwise that a member of a board or commission fits within that term as well. Metro officer acting in his or her capacity which would benefit the financial or private interest of the Metro officer or of a family member. Family member is another term we're going to discuss in here because it is important for you to be aware that things your family members do may create a conflict of interest for you with regard to your association with Metro government, not just nepotism. The term does not include actions that have what are considered a remote impact on financial interest or private interests. So what is an entity? That's the important takeaway here is, of course, that's your corporations that you're familiar with, nonprofit and for-profit entities, but it can be any unincorporated association or group. For example, a labor union is considered an unincorporated association, and there are many other versions. So anything that's an ongoing group that you're a member of, if there is a Metro action at issue that could benefit that group, whether it's registered or not as a corporation, could involve you in the conflict of interest principles. The next definition we want to look at is financial interest, and most people have a general idea what that means. The code has a very specific definition of financial interest. It is any right, title, legal, or equitable share in an asset or transaction which will result in an increase or decrease in your income or your net worth or the income or net worth of your family member. Again, hang with us. We're going to get to the definition of family member here in a moment. We had an example this is a very broad definition that I want you to be aware of. We had an example come through a trial this summer with the Ethics Commission in which the question was a non-disclosure agreement signed with a private corporation, did that alone create a financial interest in the individual who signed it? And the answer was yes, because by law, those are considered to have a value to both of the parties. And that was a contract that was signed even before employment became an issue. So there are many, many things that can meet the definition of financial interest to be aware of. And then next in slide 12 is what it means to have financial gain. Of course, that's any ascertainable increase in your net income or net worth. The important thing here is there is a de minimis exception, and the term de minimis is a legal term that means more or less something so small as to be inconsequential. So there's a little bit of wiggle room exception there. The next thing we want to look at that I've already mentioned is the term private interest. So private interest is employment, board membership, or participation in the management or operations of an entity. Remember the term entity we used. So this is where we get to the idea that you need to keep in mind most of the code applies and looks at conflicts of interest for your financial interests, so things that are going to put money in your pocket or money in your family member's pocket. But the important thing for you to take away here is you can be associated by board membership or participation in the management of a nonprofit entity, and if the Metro government action is going to benefit that entity, presumably if it's nonprofit, it's not putting money in your individual pocket, but if your action is going to benefit that nonprofit that you have that association with, it also is covered by the principles of the Ethics Code. Now, I want to take a step back here and just remind everyone that the code, and I would say Metro government in general, values its members of boards and commissions and employees. It values the fact that they associate with nonprofits. So we're not discouraging that. It's very much encouraged. In fact, we want your skill set, your memory, your experience to come from those places. The important point is to be aware that your associations like that could implicate a conflict of interest in a given situation, not to tell you that you can't become involved with nonprofits. The exception to that would be that if all you do, and I want to underscore all you do, is volunteer your time or you make financial donations to the nonprofit and you don't otherwise serve on their board or participate in the running of things, there is an exception there that you can still engage in a metro government action that potentially benefits this nonprofit without a conflict of interest issue, as long as that's the case. You're just making donations or volunteering your time. So who are the metro officers? Those are listed specifically first, a series of constitutional offices, and they're all there: the mayor, metro council members, the county attorney, the sheriff, and so on, the elected officials of metro government. The next part of that list that's also included as a metro officer are your department heads. The deputy mayors, the cabinet secretaries, chief deputies, chief administrative officers, agency directors, housing authority officer, and department director, and so on. Most of you listening are actually going to meet one of the definitions that are in slide 16 here, and that is you're an employee or you're a member of a board or commission that has the authority to enter into contracts that exceed what's called the small purchase level in the procurement code. Right now, as we speak, that's $40,000. So if you have the authority to enter into contracts in which you'll saddle metro government with the obligation to pay more than $40,000, you are considered a metro officer, and beyond that, it doesn't matter what your title is. You can be the janitor. But if in your department as the janitor you can spend more than $40,000, you'll be covered as a metro officer. And then the next one, which will be all of you on boards and commissions, you've been nominated or appointed by the metro mayor and metro council to an agency who has what's called regulatory authority, or you have independent authority as a commission or board to expend funds on behalf of metro government. At last count, we had I believe over 60 different boards and commissions in metro government, and a great many of those have what's considered regulatory authority or the authority to expend funds. Some of them don't have either one of those. If you have a question about whether your board or commission is covered, there is an advisory memo available from the Ethics Commission that specifically lists all of the boards and commissions in metro government, together with the Ethics Commission's analysis of whether they are covered or not. But that's the rule on how they're covered. Next, we're going to look at who is the family member. We keep talking about family members. The important thing to take away here is you might think you know who your family members are, but we're interested in what the code says counts as your family member, and there's some parts of it that may be a little surprising. If you're looking at the chart here, you will see that it includes your spouse or domestic partner. It includes the parents of you and the parents of your spouse or domestic partner. It includes the children of you or your domestic partner, and it includes the grandchildren of you or your domestic partner. As to you, with regard to grandparents, it's your own grandparents that are considered part of the family circle, and your own siblings. A note on the term domestic partner, and this is looked at in our slide 18. Generally, anybody who's a dependent that you're claiming as a dependent for tax purposes will fit within that definition, even if they don't meet one of the other terms: children, parents, grandparents, and so on. And then here is the important part. The Ethics Code, as many ordinances in city government, have attempted over the years to take account of what are considered non-traditional relationships. For example, household relationships with same-sex couples and the like. So, number one, those type of relationships are covered as within your orbit of family members. The second thing to note is that in the wake of the Supreme Court's decision in Obergefell that requires states to permit legal marriage between same-sex couples, That the ethics code does not turn on that one way or the other. So that if you are in a non-traditional relationship, but you as a couple have decided not to avail yourself of an official marriage, you would still potentially be covered as a domestic partner. So please be aware of that. It doesn't just turn on whether you're formally married or have a marriage certificate. All right, let's look at some of the standards of conduct. We've tried to break that down in slide 20 into what I think of as 5 broad areas of things you ain't supposed to be doing if you're covered by the ethics code. And the first one is that you're not supposed to use your official position to secure unwarranted privileges and advantages. We'll talk a little bit more in depth about what that means. The second thing is you're not supposed to act in your official capacity where you have a financial or private interest at stake, and it might reasonably appear to an objective observer that your judgment is going to be impaired if you engage in that transaction. It prevents soliciting or accepting things of value under the again, this thing with circumstances that appear to be for influencing you or for gaining access to you. There is a ban on using information that you learn through your course of governmental duties to secure your own financial gain. And then finally, it is a violation of the standards of conduct to not make the proper financial disclosures, and to not disqualify yourself from a situation in which you have a financial conflict of interest. We're going to go over each one in a little more depth, so hang with me here. Looking at the prohibition we call A and B in section 2102 of the Ethics Code, that's the unwarranted privileges and advantages section, and the section on things that appear will impair your judgment. On the first one, the thing that we want to impress on that one, that's gaining unwarranted privileges or advantages for yourself by use of your official capacity. The code prohibits you from attempting to do that, not just that you completed it, but just that you asked. So I want you to be aware of that. We have a case that we completed this summer. It's on our website if you want to read the details of the final order, in which one of the violations of the Ethics Code involved an attempt to secure an unwarranted privilege and advantage. Now, in that case, they actually went forward and got the privilege, but just the asking for it can be enough to get you in trouble. And then the second thing here on what looked 2102B, this is our slide 21 still, acting in your official capacity where you or your family member or your business organization has a financial or private interest, so remember this involves the nonprofit associations as well, where that transaction might reasonably be expected to impair your objectivity or independence of judgment. I want to talk about that for a moment. That is what the law calls an objective test. So in other words, the code would disallow you from engaging in a transaction where you've convinced yourself that you're not really doing it because for an improper purpose, and you've convinced yourself that the person offering you the thing is not really doing it for an improper purpose. You're required as a Metro official to take a step back and ask, what would the ordinary, reasonable member of the public think was going on if you engaged in this transaction? It's what I call it don't look good test. And it's real simple. If it don't look good, it ain't good. And that's all you need to know. When you're about to engage in a transaction that you know some member of the public is going to think doesn't look good, then it's probably already going to violate the code. The next thing here in our slide 22 are soliciting or accepting gifts, loans, and so on, things of value. Very, very similar to the one we just talked about, and also has that objective test. A couple things to take away from this. The first thing is it covers anything of value. Remember, we talked about the non-disclosure agreement that a Metro officer had signed with a private corporation. The only purpose of that agreement was to talk further about employing that individual. However, the law considers you, when you sign a contract, including a non-disclosure agreement, to have already obtained a thing of value. So it's not going to turn on whether you get the business opportunity or the employment later. If you've already contracted to be quiet about it through a non-disclosure agreement, you've already solicited or accepted a thing of value. The next thing to note about this is it includes the term solicitation. Again, this is an attempt type of thing. If you try to carry this out, but you don't succeed, the other side doesn't want to give it to you, or you change your mind after you've tried, you may have already violated the code by attempting to carry it out. This is also a provision that covers, in part, admission to free events, and we get a lot of questions about that. Someone has offered you a free ticket to an event that members of the public have to pay to attend. This is the first place you want to go in the code to look at whether you can accept that. As we're going to hopefully get to, there's also some other provisions that cover and govern the value of tickets that you're allowed to or not allowed to accept to such events. In general, there's a presumption that accepting tickets that are worth less than $50 do not violate the standard of conduct, and that when you begin accepting tickets that are worth more than $50, there's a presumption against you. Now, presumption means a beginning point. So I want everyone to take away that you could accept a $1 gift, but if you did so for improper purposes, as defined in this code, that is, that it appears to be done to influence you in the discharge of your official duties, that could be also a violation of the conflict of interest transactions. So be aware, $50 cutoff is not going to answer every question you need answered when you are offered free admission to an event that costs members of the public. The next thing we're going to look at is using information. That's slide 23, and that's, to our mind, fairly self-explanatory. If you gained information in the course of your governmental duties or service on a board or a commission, and that's the only way you got the information, you cannot then use it to gain financial advantage for yourself or for your family members. Remember who is your family member. And you can't do it for an organization or entity that you might be associated with, again, covering those nonprofit situations. The next, in subsection G, prevents you from representing a party or person other than your local government position in connection with a cause or proceeding before a county agency. So you can't sort of act as the advocate for some private interest to a government agency or entity once you are affiliated with Metro government, except that you're allowed to represent your own board or commission and its interests to other governmental agencies. There are a bunch of exceptions to these conflicts, so if in your mind already you're thinking, what about this, what about this, there's a good chance that it will be covered by one of those. So in slide 25, we begin the list of exceptions. It's kind of long. These are things that might be they might be a conflict of interest if we looked at them only under what we just talked about, but then they are given an exception in the code. The first one is giving or receiving a public award for public service. The thing I want to impress for you all there is public awards for public service are awards that are given for service you already did. So you completed some act of public service, maybe years of public service, and because of all that, someone comes along later and says they want to present an award to you in a public ceremony. This is not a direct quid pro quo where you're paid to speak at an event. If you're doing that, then that's not an exception to the conflict of interest rules, so you then have to go back and look at the rules we just talked about to ask whether you can be paid for that. There's an exception that allows you to take commercially reasonable loans in the course of an ordinary lender's business, and of course everyone needs that exception so they can conduct business or their regular life. And there's an exception for what's called reasonable hosting in connection with public events, appearances, and ceremonies. The thing I want everyone to remember on the reasonable hosting exception is that's not a gaping exception allowing you to then accept all those free tickets to events that have a ticket price. There's been questions like that in the past. It's not an exception that covers all those provisions. Going on to E, you're allowed to accept a gratuity for performing a marriage ceremony. I cannot tell you as I stand here today, I remember which Metro officials are even allowed to do marriage ceremonies, but if you are one of those, you can accept what's called a gratuity. Gratuities are, of course, small tips, not large amounts of compensation. And then finally, you are allowed to participate in the enactment of an ordinance, resolution, or another matter requiring a vote. So a lot of you on boards and commissions will be engaged in things that require a vote. If no financial interest accrues to you as a member in general of a business, profession, occupation, or group to any greater extent than similarly situated members. And we've had questions about this one before, so I'm going to try to describe it a little bit, what this exception means with an example. The example I like to use is if you are a barber and you are also a member of Metro Council or a board or commission, and you presumably come to your position on council with a lot of knowledge about the hair industry and barbering, then you could promote an ordinance that benefits all barbers in the metro area equally. What you could not, and then this exception would apply, because it may have benefited you as a barber, but it benefited all barbers across the city, and it was a good idea, presumably. What this would not allow you to do is, for example, create a nonprofit that promotes the interests of barbers and steer a government grant into that individual nonprofit organization that you may be a member of. So we've had requests like this. If the transaction is going to benefit you individually and not every single other member of your occupation or group, then it's not going to be under an exception of the code, and you're going to have to look back at the original conflicts of interest rules we just got done talking about. The next one, subsection I, is participating in the enactment of an ordinance, resolution, or a matter requiring vote if the financial gain is conferred on a nonprofit. So we do have an exception here, but let's see how it works so we know if we can do this for the nonprofits that we're engaged in. How can you aid a nonprofit through your actions as a Metro government official? If you have disclosed the association to us, the Ethics Commission, how would you do that? You would put that in your financial disclosure form or a supplement to your financial disclosure form, or in the case of Metro Council, you disclosed it to the clerk of Metro Council and the voting body before you acted on it. And I want to add this. When you disclose your association to the nonprofit, you don't get to just say, I have a conflict of interest, and then not tell the clerk or the commission what the conflict of interest is. You're going to need to disclose exactly what the entity is and what you're getting out of it, or what they're getting out of it. So just saying, I have a conflict of interest, and then move on is not going to do it. If you have any questions about this, of course, you can ask for an advisory opinion, and we'll talk about how those work later. And this still has the exception where if all you do is volunteer your time or make donations to the nonprofit, but you do not otherwise engage in management activities or serve on the board of the nonprofit, you can always benefit a nonprofit if all you've done is make a donation or volunteer for them. And that's on our next slide, discussed there. The next exception is you can request information or provide assistance on behalf of a citizen as long as no compensation in any form is given to or accepted by you or anybody in your family. And remember the definition of family members. And finally, we all occasionally have issues that come up in our private capacity with government. For example, assuming that you live in Metro Louisville, you could have an issue with the taxation authorities for your own individual or business purposes. It's allowed that you can interact with the officials of that agency if it's impacting your individual, but do not use in any way your capacity that's connected to Metro government when you have that interaction. Okay, so let's talk about what the financial disclosures are that you have to do. Members of boards and commissions that are regulatory in nature need to be aware that your members of the board or commission also have to file these financial disclosures. Most people know that the Metro officers have to do it, but you also do. They are filed with the Ethics Commission. The form to fill out is available on our website. It should be up there. If it's not, there's an email link on our website. You can go back and look at the slide and find us there. They're normally due April 30th of every year. We'll go through what the components are, but I want to remind you something here. 2 exceptions to the April 30th deadline for your financial disclosures. One is if you've already filed one the previous April, anytime something changes in it, you owe an updated form within 30 days of that change. I believe it's 30 days. We'll get to it in the slide. The other thing is, and this is very important for everyone running for office this year, if you are an incumbent in office that's on the ballot, you also have to update your financial disclosures within 30 days of your filing to rerun for the office you're in. This year, the filing deadline for officers, we have Metro council members and a few other offices like county commissioner that are on the ballot this year. The filing deadline was, I believe, January 6th. It was last Friday, January 6th, 2024. That would make your financial disclosures due on February 5th with the Ethics Commission. So what has to go in it? Of course, your name, your business address, the title, the occupation of you and the occupation of your spouse. You have to disclose various business affiliations and your employers. The name and address and phone number of every business that you're affiliated with that does business with Louisville government or any metro agency, and any metro officer in which anything you have an ownership interest worth $10,000 or 5% of, or you received in excess of $5,000 in compensation. So this is your full-time employers and any other way. For example, if you own rental property and gain more than $5,000 in a given year, that belongs on your financial disclosures. Number 6, the real estate that you own, the location and zoning of property in Jefferson County in which you have an interest of $10,000 or greater, or your family member does. There's an exception for your personal residence, but it's otherwise very broad. Gifts that you have received or what are considered honoraria, a gift for engaging in a speaking event, that are worth more than $200 in the aggregate from a single source. So if you did 5 speaking events and you obtained $50 gifts each of the 5 times, then you add them together for $250, which would then require you to disclose those gifts in your financial disclosures. And finally, debts or credits that you have, your debts of $10,000 or more, or debts that are owed to you, with the exception of the debt for your primary residence or debts that you accrued for ordinary household goods. So that's your ordinary household credit cards. So April 30th is the normal deadline with the exceptions we talked about. If you're newly appointed to office, you have 21 days following your appointment to file the financial disclosure. And then we talked about material changes there. That's any gift, loan, gratuity, favor, economic opportunity with a value of $25 or more, except when you have a good faith belief that it doesn't exceed the disclosure amount. The financial and private interest in a matter that's pending before Metro Council has to be disclosed, and the officer has to disqualify from participating in that matter. And that's also a disqualification provision that would cover you folks on boards and commissions. Presumably, your expertise in some areas what led you to a board or a commission, which may mean that you still engage in private transactions in that industry, and you'll have to be aware of when an issue comes before your board or commission that might have a private interest or financial interest that would be benefited as a result of it. The disqualification provisions are in 2103F. We're going to talk about those under financial disclosures in a little more depth, because a lot of people, we get a lot of questions, and we've seen instances where they appear not to understand what it means to disqualify themselves from something. So we'll go over that a little later in the presentation. The next portion of disclosure is when you have a private interest or financial interest, directly or indirectly, in any contract or matter pending before an agency That it goes on your financial disclosure form that's filed with the Ethics Commission. Who has to do the disclosures? That includes council members, county attorney, and Metro officers who derive their authority from Metro Council. Includes family members. There are provisions in the form for where you list your family member's interest. And remember, yet again, what the definition of family member is. And this has the disqualification provision. So let me step back and talk about that. So you've realized that in your position as a member of, we'll say, the Planning Commission, just to use an example, there's an individual that has a case before you and the commission is going to vote on a zoning variance, and you're a member of the commission, you can vote on it. You realize that you either own an interest in the property of the corporation that owns the property, or you are pursuing some kind of business relationship with that individual. That, of course, creates a conflict that you're going to need to remove yourself from the vote or activity. That's called disqualification. And what we want to impress on everyone is disqualification from a matter literally means no involvement at all. Bold, underline. What does no involvement mean? It means no involvement at all. Not just don't stand on the floor during the formal proceedings and cast a vote. It means you don't discuss it with your other commission members. You don't take part in any debate. You don't have phone calls on the side with your other commission members with regard to the matter so that you could convince someone one way or the other. If one of your fellow members of the commission or some private party attempts to engage you on the topic in your capacity as a commission or board member, you are to politely decline to engage in that conversation. The Kentucky, and in fact, the final thing I want to note is when the matter comes before your board or commission, you should physically remove yourself from the room during that discussion or debate. And curiously enough, we have some old case law in Kentucky that discusses that very fact, because if you remain in the room, but you remain silent and abstain from casting a vote, the law will regard you as supporting the majority vote. So you need to disappear, is the point. Let's talk about the financial disclosure forms. The next part shows where they are on our website so you can find them. And I think we talked enough about how you're going to fill those out. Questions about them can be directed to the Ethics Commission, and we'll be happy. The more questions we get in advance of doing something that might look shady, the better off it is for you. So we can just answer the question. Briefly on nepotism, so back to our definition of who's your family member, what is it you can and can't do with regard to all those family members that we talked about? I think it should be obvious to most folks, but we'll state it. It's right in the code. You can't hire a member of your family member. You can't influence someone else in Metro government to hire your family member. You cannot manage your family member or supervise them. And there's a specific section in here that talks about a prohibition from, and it lists the officials: mayor, council member, county attorney, county clerk, coroner, surveyor, or constable. Prevent them from employing at all a family member anywhere inside their office. So that one covers, they can't work in your office, whether you're directly supervising them or not. This used to be a fairly accepted practice across the state and is in some areas that don't have ethics codes. So it was necessary for the code drafters to come out and just say, for those specific officials, family members can't work in your office at all. Next thing I want to note is this covers more than just traditional employment. These prohibited nepotism transactions cover also appointments to positions. That's you if you're on a board or a commission. So there need not be a salary. You need not be considered a traditional Metro government employee. If there's a position that exists, which includes positions on boards and commissions, one cannot appoint or seek to appoint a family member to that position or try to influence someone else to appoint a family member to that. Nepotism covers those. One area that's under consideration right now, and we don't have a definition of yet, but we should have an opinion shortly, is whether there's any exception for what is a volunteer that is not considered appointed to a position. The term of art used by the code is appointment to a position, so the commission will be ruling on whether volunteers are or are not covered by that provision shortly. Watch our website for that. So who are we, the Ethics Commission? How does all this work? You might know that there's a process for making complaints. Either you made one or you were the subject of one. But we also have a process for advisory opinions, and that's what we like to impress upon folks covered by the code more than the complaint procedure. We are required to issue them. Any Metro officer, a candidate for Metro office, a housing authority employee, or now a lobbyist may request those advisory opinions. We get plenty of requests from members of boards and commissions too. The important takeaway here, all you have to do is go online, look for our form, fill it out, and send it back to the Metro Ethics Commission. We normally meet once a month. We do have a process, if it needs to be expedited, for giving you a provisional opinion before the full commission meets to consider it. So you want to say what your time frame is. And please be aware that if we're getting it last minute because you didn't bother to ask us till last minute, we may or may not be able to fulfill your request. But things come up faster than our monthly meetings, so we try to answer those with a provisional opinion. We do try to answer you back in your time frame that you're asking for. The more facts you provide, the better. I would say an easy majority of advisory opinion requests that we receive don't contain enough facts up front for us to finish the opinion. We usually have to come back and ask for more information. So provide as much as you can. The final takeaway about an advisory opinion, these are not intended for something you already did. So we've learned a little bit about the ethics code. We've learned a little bit about how to avoid conflicts of interest. If you went ahead and did it anyway, thinking you were allowed to, don't come to us for an advisory opinion to stamp with our approval what you already did. The code doesn't allow us to do that, and in fact, if someone makes a complaint against you, you may end up in the complaint procedure, so ask before you act. And the complaint procedure is next. That's what we'll talk about. Who can file a complaint? Any person, and it means any person. You don't have to be affiliated with Metro government. You, in fact, don't have to have exactly first-hand knowledge of what you're alleging to be true. However, you will be required to state your name, and you will be required to swear under oath to the things that you allege in the complaint. It has to be filed within 1 year of the event that you claim is a violation of the ethics code. And if it doesn't comply basically with the ordinance, it will not even be filed in the records. So, for example, we sometimes get complaints that appear that simply don't imply anything in the ethics code, but they might allege a violation of law in some other way. Someone is angry or disgruntled at a Metro government official or against a member of a border commission. They put a series of allegations in there that don't have anything to do with our conflict of interest principles, but maybe it's the basis for a civil lawsuit, maybe it's the basis for a criminal allegation. If it doesn't meet the ethics ordinance, we're not going to file it, and we're going to inform you that it's an improper complaint. The commission has the authority to dismiss without any further hearing complaints that are determined to be frivolous or are being done for the purpose of harassment. Now, I want to point out something here. Lots of complaints are filed in who knows what the individual motives are of the individuals filing the complaint. This is going to be a test that it's done for absolutely no other purpose than to harass someone. So in other words, it doesn't appear to state anything valid in the first place, and the complainant, the target of the complaint, can validly say they don't have any purpose other than to harass me. We're all very well aware that people carry their private motives, sometimes rooted in partisan differences, personal differences. That alone is not going to cause a complaint to be ruled invalid if it states what appears to be a factual basis for a violation of the code. What I can say about that is the code drafters in general erred on the side of opening up the complaint process with the realization that some people are going to have angry motives for filing those, and it's not a basis to dismiss it by itself. Going forward from there, We can request independent counsel to represent the complainant if we feel it's necessary. We won't necessarily appoint a lawyer to someone who filed a complaint, but we will in cases where we think it's necessary. The person who you filed the complaint against is supposed to be served with a copy of it within 10 days. Or if you're the subject of it, you're supposed to receive service of a copy of it. When you do get one, do not toss it in the trash. Don't put it on a stack of papers. Don't put your head in the sand. You have to file a response to it within 20 days. And for those of you who have any familiarity with the legal system, that's the exact same amount of time you would have if you were served with a complaint in the legal process. Metro officers have the right to appointed legal counsel, and there's a provision for paying them. We may choose to go forward and conduct an independent investigation, and we will have the authority to determine whether ultimately it states a complaint or not. Could we stop for a second? Oh, have I really? So we may be able to, if you can send me this, we may be able to cut out some of what I talked about, because I want to at least mention employee protections and lobbying. So if you want to cut out some other part, if we go ahead and film that part, and then, is that okay? Okay. Yeah, I can do that. Mhm. The next thing we want to touch on, we're not going to get into this in serious depth, but there are a series of protections for employees and subordinates that are rooted in the Ethics Code. Looking at slide 53, a Metro officer shall not compel a subordinate to engage in a financial transaction, including the giving of loans or charitable donations. They shall not compel a subordinate to make a political contribution or to aid an election campaign. There's a long definition of what it means to engage in inappropriate political solicitation. So if you are either the subject of someone that you think is making that type of solicitation, or you're entertaining doing it yourself, refer to the code for more detail about what does and doesn't violate the code. Want to point out there's a special provision covering public housing authorities. We're not going to go over that in depth today, but if you're an employee or a supervisor at the public housing authority, you want to look at the specific provisions in the code. And then finally, I want to mention this year's newest addition to the Metro Ethics Code, which is lobbying. And what I want to impress on all of the audience today is that lobbying is a very, very broad definition. So an individual can be what the code regards as lobbying you, even though they've never registered, they don't carry a card that says, I'm a lobbyist. It's not official. They're not hanging out in the hallway, with a card. Lots and lots of activity. Any direct communication with a Metro officer or another individual covered by the Ethics Code, which is done for the purpose of influencing your official decision, can be lobbying. There's a long list of exceptions that we're not going to be able to go through completely. You can refer to all these in the code. There are still things citizens can do to try to influence government activity and not be a lobbyist. But if, as a Metro officer or a member of a border commission, you think you are being lobbied, you can look to the definition. If it looks like that's what the person's doing, all you have to do is tell them to go to the Ethics Commission website and register. Just register as a lobbyist. There are various things they're going to have to disclose, but in general, anyone can register as a lobbyist. So to some extent, this is for your self-protection when someone is discussing with you, attempting to influence your opinion or official decision. That's it for the Code of Ethics for today. Remember, our website's available, our advisory opinion process is available, and we have an email process for questions and concerns, which we are happy to try to answer for you. Thank you very much.